Yeah, we have a lot of power. That's the high note, right? Like we can create our own legal structures and we can show to the world that our combinations of tech and and agreements are better than anything that existed before.
Hey, welcome to Next Meta, a podcast and a newsletter about on chain economies, coordination, most effective tactics, and the bigger picture. Serious topics and a not so serious host. Hope you enjoy. Welcome, Gabriel, to the Next Meta podcast.
Thank you, sir. Glad to be here.
Yeah, Gabriel is one of the most well known, if not the most well known, crypto lawyer. You've seen him around the crypto Twitter, most likely. But let's have him say a bit about himself for the people who might not know you.
Sure, yeah. My name is Gabriel Shapiro, and I have a Twitter presence where my name is LexNode, so people may know me that way as well. I've been a corporate and securities attorney for around 14 years total. About half of that has been really focused on crypto. And the first half, I was a very traditional buy side mergers and acquisitions attorney at a big Wall Street firm. And now my most recent project, which I guess we'll talk about, is founding a tech slash law company called MetaLeX.
Awesome. Yeah, we will definitely get into that, but let's start in a bit of history. So, a lot of people find law boring, and I wanted to ask you, why do you find it fun? Like, what got you here? You
Well,
seem
I
pretty
think
hyped
law
about what
can
you do.
be, yeah, I think law can be interesting. I mean, it certainly can be boring. I find most tax law pretty boring, for example. I think law can be interesting though, and my what I used to do when I was a more traditional attorney is I did deals. I did big mergers and acquisitions deals, and really they're interesting for a lot of the same reasons that crypto is interesting. They're all about incentives and trying to set up structures where people will honor their commitments in a sort of trust minimized manner, right? And so for many years I was doing that by writing words and trying to set incentives that way, right? And now I operate, more in a hybrid space of doing it through, a combination of words and awareness of crypto mechanisms. But at the end of the day, it's all really the same stuff. It's just that crypto is a much more efficient technology for it than just writing words and running to courts to make them enforce the words.
Right. That makes sense. And yeah, do you see more of these like the crypto words, like the code itself, being enforced in the like the traditional justice system? Or like, do you see more and more smart contracts tied to like Ricardian contracts?
Yeah, well, I mean, I think so far, unfortunately, the court systems when they've faced challenges related or disputes related to crypto issues, they don't really understand them very well. And the way I like to explain this is that crypto is, for the most part, a realm where people's behavior is governed by powers and incentives, right? Like you don't really have some kind of intellectual property right or license or contract right that enables you to use Ethereum. What you have is, a key and specific software that, in a specific configuration that just enables you to use that network, right? It's not really a matter of rights, it's just a matter of powers. And similarly, if you are doing something on the network like staking ETH to do validation, or you're using an app and you have a token, or you're trying to get a token, you've had an incentive set, but you haven't entered into an agreement sort of prescribing specific duties. Like if you borrow from a lending protocol, for example, right? There's no legal agreement there. You haven't actually promised to repay, but you've deposited some collateral that gives you an incentive to repay. And if you don't follow that incentive, well, fine, they just liquidate your collateral and you're done. There's no notion of them suing you afterwards to get the residual amount of money or anything like that, right? And the legal system, on the other hand, is built on a framework of rights and duties, right, or rights and obligations, or rights and liabilities, and that's just very different. And you see it in cases like the Avi Eisenberg trial, where they kind of shoehorned some part of his conduct into like this sort of framework where he was being alleged to have given fraudulent misrepresentations for a loan and to have like breached the loan contract by not repaying the collateral or something like that. Nonsense. It's just nonsense. That's just not how crypto protocols are built. But that is how to a hammer everything looks like a nail, and to a court everything looks like rights and duties, right? So there's a bit of a clash there. I think Ricardian contracts and things like that can help with that, right? Because you can be more specific that there's not supposed to be a right or an obligation. There's only supposed to be a power and incentive. And maybe if a court sees that and sees that written in a contract, then maybe they will respect that, right? But yeah, that's sort of the direction that it goes.
Was the craziest or most interesting case that you worked on?
Case that I worked on, well, I don't really work on litigations per se. I'm more kind of help people structure things up front. Certainly in terms of craziness, I mean, just being in the heyday of Terra, honestly. I was working on a couple of DeFi protocols on Terra when Terra was really popping off, and in terms of just sheer craziness and just being relevant to all of crypto and all the legal issues that were going on, especially as it collapsed, right, and seeing all of that unfold, and like having validators DM me just because I was a known lawyer in the ecosystem and be like, am I going to prison? Right? Like even like validators are worried about going to prison. I would definitely say that was up there in terms of craziness. Yeah.
Yeah, I saw some the other day. Somebody wrote like a negative comment on Twitter about your involvement in the Luna case, and then people commenting, "No, like, fuck off, Gabriel is a
Yeah, I mean, I
legend."
was just like, yeah, my involvement was like pretty, I was just like, it would be sort of like blaming the GC of Uniswap if like something horrific happened with Ethereum itself, right? Like I was just, sort of like a publicly known GC for a couple of like DeFi teams, on Terra, but unfortunately, yeah, that you can get a bad reputation that way as well. Even if you
Right.
never, even if you weren't like friends with Do Kwon or whatever, right? Yeah.
But sounds like it didn't catch on because like
Right.
all the other
Yep.
comments were defending you. So that was nice
Yeah,
to
yeah,
see.
yeah. Yeah, yeah.
Yeah, people know you're legit. But what I was going to say, like in regards to recording contracts, what do you think about projects like Ethereum, which tries to like connect physical objects to NFTs, which represent legal ownership?
I don't specifically know that project, but Materium. Okay, yeah, yeah. I thought you said Mytherium or something. Oh yeah, yeah, I like Materium a lot. I think it's probably the smartest, sort of like most um like legally compliant approach I've seen to sort of asset tokenization, for lack of a better word, right? Where they try to correlate. A lot of so-called asset tokenization isn't actually asset tokenization. It's actually what's called securitization, and it's what's called asset-backed securities, right? And this is a pretty difficult thing to do crypto natively because of the regulations that apply. The Ethereum approach, as I understand it, is to avoid making asset-backed securities and instead actually kind of tokenize assets one to one. That is, the tokens are like literal floating claims to a specific asset or assets rather than to some like rather than being like a share of an LLC where some pool of assets is professionally managed. So I think that's like really cool, and that's basically like the most quote unquote cypherpunk way of trying to bridge the on-chain world to the off-chain world, because it doesn't empower an intermediary, right, and it doesn't trigger sort of like highly onerous obligations. So yeah, I think their approach is really cool, and I kind of tend to refer to that style of approach as cybernetic law, right? And I try to do similar things when it comes to other types of agreements or dealing with off-chain entities that use on-chain technology.
Right. So I would say that that's one of the approaches that makes most sense. And yeah,
For
they've been
sure.
at it for many years, and I know that they had many lawyers involved in shaping up Ethereum. So
I
yeah,
bet.
I'm
Yeah,
glad
they've
I'm
done
glad
some
to
cool
see
stuff
some.
like they tokenized, like they had an NFT that represented, specific, like a specific real estate, right? And that was up for sale on OpenSea. I think they did some kind of like Star Trek merchandise NFT. I think they might have done gold or something.
Yeah,
Yeah, and all
yeah,
really cool stuff.
mm. Yeah. They had the figurine signed by William Shatner.
There you
But
go.
what was I gonna say before that? Yeah, what's like the most shadiest or like the worst executed kind of real world asset sort of project that you've seen?
Well, I see. I mean, I think they're all kind of shady in a sense because they, while technically they may be legally compliant, like I think it come like all these sort of yeah, I hesitate to name specific projects, but basically there's a way you can do, sort of at like securities tokenization that I think is very contrary to the spirit of what we're trying to accomplish in the space, right? You can basically just form an entity, you can have it buy a bunch of treasuries, right? And then you could, just basically issue a token with like no rights attached to it. USDC is almost a little bit like this, in fact, right? USDC really doesn't have any rights, but people depend on it nevertheless. But the assets backing it, so to speak, are just managed by this sort of black box entity, right? And in theory, it could be doing. I'm sure Circle's not doing nefarious stuff, but in theory, it could be doing all kinds of nefarious stuff, and no one would know. No one would have the right. No one has the right to, get disclosure, as a third party or to bring a lawsuit as a mere USDC holder, because it doesn't have any rights attached to it, right? And so it's almost kind of like the opposite of the Ethereum approach. It's like it's all intermediaries. Like the intermediaries are omnipotent, right? And the token is sort of a pale shadow, that you hope somehow tracks that value, but there's no real mechanism to make sure it does so. And I think that's just they do that in part. In Circle's case, I think they probably would like to give people more rights, um, but they do that as sort of a different kind of regulatory dodge, right? The idea that if something has no rights, then it's not regulated. Um, but it's kind of contrary to the idea of our technology, which is to power individual people directly, and not have to depend on intermediaries. So I hope we can evolve, real world asset tokenization to be somewhat more like bearer securities or something like that, and really leverage the properties of this technology that disintermediate, people and give or disintermediate institutions, I guess, and put the power directly in the asset holders' hands.
Right. Yeah, definitely not very cypherpunk.
Yeah,
All right, let's get into MetaLeX and BORGs. So
sure.
I guess it makes more sense to start with MetaLeX. So what is MetaLex?
Yeah, so MetaLex is basically, a group of lawyers and coders who have gotten together to try to, um, like, finally make crypto and law work together in a cypherpunk way, as we've been talking about. Um, we have both a law firm and a tech company, and we are basically, you know, building legal solutions and tech solutions that work together, right? So the first example of that is what we call cybernetic organizations, aka BORGs, and specifically DAO adjacent BORGs, where basically, like multi-sigs, the DAOs that rely on multi-sigs or use multi-sigs, and for various kinds of like you could call it delegated authority or constrained delegation or work. Um, that we were able to put those multi-sigs into legal structures, mostly Cayman's foundations in most cases, combined with a set of on-chain smart contracts that that work together harmoniously, and punt as much of the enforcement costs, transaction costs, trust minimization costs, all these things to the on-chain component as we can. And when we can't do that, we use the legal side of it to gap fill, but they work well together. And to do this type of approach, you really need a team of lawyers and developers who, share a philosophy and share a company and a set of incentives and work together. So that's what we're doing in a nutshell at a very high level.
Yeah, so let's go deeper, like some more
Sure.
specific projects or yeah.
Yeah, so the first thing we're really focused on is DAO adjacent Borgs, and and honestly, I consider like the first Borg to have been Metacartel Ventures DAO. It was called a DAO, not a Borg, which you were part of as well, I believe, right? And I did the legal structuring for that, and really what it is, it's actually just a venture fund that uses smart contract logic and in such a deep way that, its legal documents actually say, well, to vote, call the vote function of the Moloch DAO contract, right? And to claim your assets, call the claim assets functions of the Moloch DAO. Like it literally says that in the agreement. And I think we just need more of that in general. I think that's the proper way to kind of navigate this new way of the intersection of law and crypto. Let's say that you have to be very specific. You have to make sure everything matches, right? And you have to do legal engineering. And so what I noticed as I counseled a lot of DeFi projects in recent years is that there are really no pure DAOs anymore, and people hate DAOs, like just pure naive DAOs, right? What they want is kind of like a DAO to serve as a very broad decentralized oracle that informs the work of, more adjacent centralized groups, that are more like traditional entities, right? And so, I would be counseling projects on how to do this sort of thing in a way that doesn't just revert back to traditional structures, doesn't just, go back to turn DAOs into corporations, for example, right? You don't want the DAO token holders to just be like shareholders who are electing a board of directors and a CEO and stuff like that. And the kind of patterns that I was coming up with were, okay, let's just have a bunch of autonomous legal entities surrounding the DAO, and they're truly autonomous. They have their own business models. They have their own concerns. They're not sort of even completely transparent to the world. They're managed like normal companies. It's an LLC or it's a foundation company or whatever it might be. But but it's lame to just have it be totally centralized, because then obviously, it could just do whatever it wants, right? Including it can rug the DAO, right? I mean, I think we just saw like $200 million or something go from the Arbitrum DAO to some like video game thing, and people are very nervous about that because, like, in theory, it's basically just a grant, and they could do almost anything with it, as far as I understand. So it shouldn't be like that. Instead, there should be rules in the documents of these entities that require the entity to at least consult with the DAO about certain topics, and that if the entity breaks its own rules, that the DAO would be able to hold it accountable in some way, right? So, let's just say it was this video game thing. Then the video game might be like an ownerless Cayman's Foundation, and it would have in its rules, hey, everything we do with our money has to benefit the Arbitrum ecosystem. An Arbitrum ecosystem would be defined in some way. And then if they broke that rule, it would have a further rule in the documents that says, anytime the DAO thinks we broke our own rules, the DAO can appoint a person by a vote, and that person actually has the legal right to come and sue us for breaking the rules, right? This is just a very simple, purely legalistic mechanism for doing this, right? And that works. That actually is enforceable, right? Because under Cayman's law, there's a role called a supervisor, right? Which has both statutory authority and contractual authority under whatever the entity's bylaws say about it. And so if you just say in the rules, the DAO can appoint a supervisor to hold the Borg accountable for breaking a rule, that's enforceable. And so that's just a very simple way where you can create more accountability. Then you can get to sort of a further layer of it. Well, okay, the DAO gave a bunch of money to this entity. What if we require that money be held in a multi-sig, right? And at least that way it's on chain, it's transparent. And what if we told the DAO who all the signers on the multi-sig are? And what if, in order to appoint a new signer, both the existing signers and the DAO have to approve that, right? And what if they try to spend too much of the money too fast, that the DAO can veto that, or the DAO has an approval over that, right? Like what if it's programmatically rate limited how fast they spend the money? So you can go further and further down this rabbit hole, but at the end of the day, what you have is you have a highly compatible combination of legal rules and on-chain rules that, without giving the DAO like shareholder rights, still give the DAO a fair amount of visibility, accountability, and influence into what these autonomous entities are doing, still constrain their discretion, and they basically just trust minimize things, right? And that in essence is what a DAO adjacent Borg is, and that is what we're focused on building. So we're building it on the legal side with like a set of template docs and helping specific clients implement it. You may have seen, ZK Syncs like a preliminary announcement about their structure. We've worked with them. It's very Borg-like, right? There's some other ecosystems working on it, and then we're building a set of smart contracts that basically modify the standard Gnosis safe to allow this sort of more constrained operation, like rate limiting or down vetoes or whatever it might be. And we're building, like a sick web platform for that, and it will all just go together and kind of constitute a combined legal tech platform for Borgs.
Got it. But you're referring to the Borgs as these smaller organizations, or is the DAO itself also a Borg?
No, the DAO's a DAO, and the DAO could either have no legal entity, or it could be wrapped in some sort of DAO-specific legal entity, like a so-called DUNA, or a Wyoming DAO LLC, or whatever you want. But the Borgs are separate entities, that are sort of clustered around the DAO. So it's a little bit like a hub and spoke model, or something like that. It's also, you could draw parallels of it to like how modularization is proceeding in the blockchain space itself, right? Like the way Ethereum is spinning off these L2s, right? But the L2s are still, they're very autonomous. They might have their own token and their own business model, but they are, in a sense, accountable back to the L1 Ethereum itself in terms of like these core security guarantees. Very, very similar with Borgs and DAOs, right? There's kind of a core security guarantee that comes from the DAO, that makes the Borg follow its own rules.
Got it. So Borgs are really like a way of keeping these autonomous teams more accountable to the DAO itself.
That's right. That's right. So it's similar. You could also compare it to like the sub-DAO model, or like Hats protocol, or some of these other things, DAO. The reason I don't like the sub-DAO model is because the DAO then has too much power, I would say, and it is much more in the role of like shareholders. Like it can just arbitrarily revoke funding at any time, or like just shut the thing down at any time. From a lawyer's point of view, in terms of like the regulatory issues we're trying to address and so on, and even tax issues and a lot of other things, that makes the DAO overpowered, where the Borg is kind of in the middle, right? It's independent, but it still has some level of accountability back.
Right. Yeah, sub DAO makes it sound like it's just owned by the main DAO. And also it's not very
That's right.
applicable
Yeah.
in all cases because like most of these organizations will go on to raise funding from other big DAOs or even from VCs. And
Exactly.
at that point, it's like, whose sub DAO is it? Like, yeah, it's
Exactly.
a
Yep.
Borg, I guess. But so
Yep.
then a Borg can later evolve into a DAO that has its own Borgs, like surrounded by its own Borgs.
It could. Yeah. I mean, that's a really good point. It certainly could. Yeah. Indeed. And I think we'll see as all this stuff evolves, I think we'll see like really crazy stuff. There's a project. Why am I blanking on the name of it? I think it's called Time Wave, by Sam Hart. That's working on these things they call covenants, which are kind of like DAO liquidity sharing arrangements and things like that, right? And you could also imagine similar things in between borgs, or like even like tri-party or four-party agreements where like some set of borgs and DAOs agrees to like share some liquidity pool, each in accordance with its own rules. And so we'll get like very, very interesting arrangements where like borgs start to like be involved in one another's governance, and DAOs start to be involved, and you could almost have like nation states emerging or things like that, like a nation state of DAOs and borgs. Yeah, very interesting.
That's gonna be super interesting. But what was I gonna say? Yeah, like the decentralized organizations from before DAOs, like higher. I don't know what's. There was a few more big ones on the list, like Morningstar. I'm not sure they operate the same way, but what I noticed is a bunch of the biggest pre-DAO decentralized organizations actually operate on a similar model where they're this main organization, but it actually operates like sort of an internal marketplace where these what we call DAO, sub DAOs in the DAO space, and they're all like LLCs of their own, and they have their own autonomy and whatnot, but they have all like profit sharing agreements with the main organization, and between each others they have different commitments and different revenue models and how they share these profits. So yeah, I
Yeah,
think it makes sense that the DAOs are also evolving in this direction, whereas like what versus what we started as like building these monolithic DAOs.
that's right. Yeah, I think everything in the space is like headed toward modularization. Totally.
Yeah. So what else? What's the meta? So meta, that's the kind of the signature question of this podcast series. And what's the meta? It can be like meta
Right.
as in what do you think is the current most effective tactic, but it can also be like a meta as in the bigger picture.
Yeah, I think the bigger picture is, that Bitcoin kind of separated money from the state, right? And I would say Ethereum kind of separated finance from the state. And I think that there is a third, like with all of the regulatory, like just look at the last few years with like the FTX collapse and the war by Gensler on crypto and just all these things. The I think the third frontier is separating law from the state, right? And I think the building out this type of infrastructure, even though it currently depends on the existing legal system, right? Like it depends on Cayman's law, for example, to have this like supervisor mechanic. But ultimately, I think what we should be working toward is separating law from the state using these same technologies, right? And I think
Right.
as we, like as DAOs and boards kind of self-assemble into things like leagues of nations with these sort of like on-chain treaties between them, we can get to something very like that. I think they're like I don't think it can ever be purely on-chain though, right? Because there's just always subjective things in law, and even even like the most hardcore like ETH developer will tell you that ultimately ETH security is backstopped by social consensus, right? Like the threat of like slashing for out of like social slashing, for example, if there's censorship, right, can't be enforced automatically. It would have to be done socially. And so you need like in order to avoid just having like rule by Twitter, so to speak, or like kangaroo courts, we do need something like our own law, right? With like precedent and people who are experts in applying the law and being consistent and giving good reasoning, about why things should be a certain way and having legitimacy to that. But so we need the same type of thing we get in traditional law. We should use smart contracts and other tech as much as we can, but ultimately like we need our own precedent, and no one's currently building that. I'd love to build that at some point, but it's hard. Yeah.
Right. Yeah, there are like a solution to small problems like smart invoice where you can raise the issue, like dispute it by like elevate it if you're not agreeing. But have you seen any like sort of decentralized court do it well? I remember there was a Aragon jury which kind of completely flopped. I remember it
Yeah.
was kind of ill-conceived. I thought Claros
Right.
was doing well, but then I heard other people explaining that they're not doing so well either. But I don't understand law, so I don't know how exactly
Well,
it
I mean, I
works and
think
how
these
it's
are like
supposed to
very like
work.
Yeah, I think these are like super interesting and valuable experiments, right? The problem, and Claris is very cool, and I think they're coming out with like a V2 that should be much more flexible. But fundamentally, relying on a crypto economic mechanism alone to decide legal disputes is in my opinion never going to work, right? Because it like they give you an incentive to come up with the right answer, and in general it's like cheapest to coordinate on quote unquote the truth, but like the truth is rarely clear in like a true complicated legal dispute, right? Like questions of right or wrong, or like questions of morality certainly come into it, right? And so just having a crypto economic incentive is not really enough to reach the right result. You need kind of like a set of institutions, and you need procedures for fairness that take account of things that are not just on chain, right? Like why like in traditional courts there's a process called voir dire, right, which means in French see what they say, right, for jury selection, right? And it's not anonymous, and it's not just based on staking some token. You actually question the jury and make sure that they are impartial, right, in every way. And you counsel them. There's a judge. There's no judge role in Claris. I guess that's really what I'm trying to say, right? The judge role is very important. He's a referee. He helps sort who the jury is. He helps limit the jury in making sure that they're assessing the dispute according to the right factors, right? And they don't get to consider everything in the world to decide. They have a more limited set of evidence that is deemed relevant by our institutions to deciding that particular type of dispute, right? Like they're not allowed to go and watch TV and absorb Tucker Carlson's or Nancy Grace's opinion on some murder case. They're told not to do that, and in some cases they're prevented from doing that by sequestration. And that's a big part of what makes the justice system fair, right? This due process. So I don't think crypto economic mechanisms can ever get there alone, right? And so to truly do this, you need a mix, and no one has designed that yet. But I'd like to try to design something like that because I think it could be done. I think it could be better than the existing legal system, but just no one has really gone there yet.
Got it. So that's one of the things that you hope to do after you're finished with the Borg project.
Yeah, we call that phase three. So MetaLeX, like the MetaLex white paper, kind of sets out three phases. Phase 1A is DAO adjacent borgs. Phase 1B is non-DAO adjacent borgs. So just think about like a heavily tokenized venture-backed corporation, for example. Phase 2 is deal technology, which we've actually started building, ended up building a lot of during phase 1. But so think about like protocol M&A, right? Where you can merge two tokens together, or a lot of escrow arrangements or the covenants that I was talking about earlier, that sort of thing. And then phase 3 would be this crypto native law, right? And that's really the ultimate goal. But I think you need these other pieces. You need, like, if you were to have a court, a decentralized court, for example, it would have to be some kind of Borg, right? So we have to build Borgs first before we can build the justice system.
Yeah, decentralized M&A, that sounds interesting as well. A deacon from Dalhouse
Yeah,
wants to build a game that's about it. I don't know if you've seen that. That's something you
interesting.
might
I
be
haven't seen
interested
it. A
in
lot of
reading about.
there's a
Yeah.
lot of buzz about Yeah, there's a lot of buzz about trying to do token M&A, and I think like JP from Thorchain, I think he's working on a bunch of that stuff. And I think there was like Ocean Protocol did something. I haven't followed everything super closely, but there's a lot of the ideal that you would want, right? Because mergers in the real world, the reason why mergers can happen is because there is a specific merger statute. And the statute says that if the corporation's board of directors and a majority of its shareholders have approved the merger, then it is deemed to be the case that all of the shares convert into some other shares or some other property that's specified by the plan of merger. So this is an act of legal fiat that sort of, as long as the governance process for deciding it was legitimate, it actually drags everyone along, right? There's some complications with dissenters' rights and stuff like that, which I won't get into, but there's some minority protections in case it's an unfair deal, but the we don't have the equivalent to that in crypto because there's nothing to like force a minority of token holders to go along with this plan. You can maybe just offer them
Mhm, right.
some exchange or whatever, and in the real world, there's also a bunch of regulations around what is a fair type of offer in that context, right? And what is an unfair type of offer, right? Because you could imagine very draconian offers like, we'll give the first 50% who agree to this $60 per token, and then we'll give the next 50% $1 per token, right? Well, of course, everyone's going to rush,
Right.
right,
Putting
to
on a
be in the
bonding
first
curve.
50%, right? And so like that's illegal in the real world, right? So there's like a lot of stuff that would need to be figured out to actually make this work. And right now the experiments I would say are like very naive, crude, and primitive. But at least there's something, and it shows that there's a real need there for maybe some kind of M&A protocol that gets baked in just like any other ERC, type of standard into every token at some point. That would be the ideal.
And how do you think it worked out with Ocean? I think they like merged three projects together, or at least three tokens. So it was
Right.
Ocean, Render, or Fat. I'm not sure which ones, but I remember there was three of them, and I was like, like I've never heard any crypto projects merging before.
Yeah, I need to look into the details of it. Honestly, I'm not. Yeah, I mean, I heard about it, but I don't know all the details. Unfortunately, super interested to dig into that more.
Yeah, like it opens possibilities, but also yeah, makes it restrictive as well because it's in code. Like the token is code, you can just
Exactly.
do
Yeah.
what you want with it. It's interesting.
Yeah.
Tell me more about MetaLex. So what's there besides BORGs currently, or are you mostly focusing
Yeah.
on that
Well,
right
I
now?
mean, we also have sort of like a normal crypto-oriented law firm, right? So, we do like kind of the usual crypto VC financings and things like that. So that's all there. And we were kind of incubated by Delphi Labs. The original kind of Borg article that became pretty well known was published by Delphi Labs. I wrote it, but it's was all kind of done there. And then Cyberfund is one of our other kind of like the biggest investor in it. They're kind of legends and yeah, have been super helpful. And Seed Ventures Club as well. So those are kind of our investors who we're very grateful for. And right now, all the initial kind of V1 of the board protocol is almost done with audit. Actually, we just submitted the second set of changes. So I'm hoping that we might be like have our web app and the smart contracts in prod with a few clients sometime in August. So that'll be cool for people to check out. And we also have an escrow product that we've built alongside it called Lexcrow. That's kind of like just like a very, very overpowered escrow protocol that can pretty much do anything from like air swap style OTC token swaps to peer-to-peer bets to just about anything you would want. And we've also built a new token vesting protocol that is much more legally sophisticated than the other ones, I would say, in terms of, it kind of has multiple curves for both like vesting and unlocking, and it enables kind of like actual like you could structure it as an option and you can pay in the exercise price to get the tokens. You can structure it as a restricted token where it's kind of initially vested but subject to buyback at a certain price by the project if certain conditions aren't satisfied. And it even has internal governance of the rewards, just like a normal option plan would, or a normal every nowadays most like SAFs, for example, they're actually amendable by majority, right? So like if like for example, I think Delphi Ventures was invested in DYDX. and they kept extending, the lockup period on the tokens, and we would just kind of get a notice saying that, oh, it's been amended. But I mean, if you think about it, why do they have the power to do that? It's because there's a provision in the agreement that says if like a majority in value of the SAFs plus the company agrees to amend the terms, then that's binding on everyone, right? So to like really do on-chain token options, or even like tokenized stock options or whatever, you actually need to have internal governance in the rewards. So we built all that to make it work more with our legal agreements and that sort of thing. So that's kind of like the first three things that we'll be coming out with. And yeah, I'm super hyped for people to start like actually using it and building more and more kind of use cases on it.
Got it. So in the case of the DYDX, or like, yeah, any project doing something similar, theoretically could have like the 10% of the currently liquid tokens, just like defer and defer the other 90% unlock indefinitely.
No, you couldn't. Well, yeah, you wouldn't base it on that. You would base it on the people who are all in the same boat, right? That's the way it's done in legal agreements, right? Because yeah, otherwise it would be ridiculous. Like people could just hold them hostage. So you typically, like, everyone invests in a certain round of SAPs. There would be like a group amendment mechanic for that particular round, for example.
Got it. But yeah, sounds like you have a whole bunch going on. And when is the escrow project coming out?
I think they'll all come out in. I mean, all the smart contracts and the initial web interface will be done in August. But the first use cases we'll support, I think, will be like a grants borg and a security borg, right? Both DAO adjacent. And then we'll just keep adding more use cases from there, right? So the grants borg uses the vesting product because they may wish to, like, when a borg gives out a grant to some team, they probably want to vest the awards over time. So it uses it for that purpose. But there are just many other applications. We'll probably build like a standalone vesting app, a standalone escrow app. I was thinking about maybe doing like a KOL clout betting app, just as kind of like a fun thing to demonstrate the power of the escrow product. Maybe take some work away from Kobe, because he's currently the escrow of choice for most KOL bets. But so yeah, that's kind of what we're planning, and yeah, there's a lot to do, but it'll be fun.
Got it. So I initially thought that you're already building all of these as separate apps, but you're actually building like a single platform with all of these different modules or features.
Yeah, the main one will be Borgs, but we'll build little sub apps within it, yeah, that people can maybe have some fun with.
Got it. That's cool. All right, and yeah, let's end it with something like, what do you think the scariest law-related case, or what's the most fun thing that you saw recently?
Uh, well, I mean, it's scariest. There's kind of two things that I'm most worried about in terms of how law evolves for crypto, and that I think people are sleeping on, because everyone is focused on the SEC threat, which I understand. But in my opinion, there are much bigger threats. One of the big threats is the CFTC's actions against DeFi protocols, right? Because basically, commodities derivatives law in the US is based on a philosophy of mandatory intermediation, right? Where, there are just a very small number of platforms that get these difficult to obtain licenses, and those centralized platforms are supposed to be the only place where you can do leveraged commodities trading, for example, right? And so the CFTC has really gone after DeFi protocols over leverage, as well as what are called swaps, which is basically like any instrument that's dependent upon the value of like other assets, right? So, like the classic case of a swap would be, well, some kind of like maybe like a synth, right? That's tracking like Apple stock or something like that, right? Like, would arguably be a swap, but really anything that represents something else could in theory be a swap. So like your A tokens that you get out of Aave as like a receipt for your debt position in Aave, could conceivably be a swap, right? Almost anything could be
Right,
a
or any
swap,
pool
like
token.
liquid staking protocols or liquid restaking tokens. All these things. These things are very, very, and obviously even more so perps, right? I mean, those are even called perpetual swaps, right? And so, like, if all these things are required by law to be intermediated, crypto is absolutely decimated. The whole point of it is to disintermediate, right? And so people are dramatically sleeping on this. And not only that, the CFTC is seen as kind of like a better regulator for crypto than the SEC. So there are all these bills floating around in DC, basically just giving massive new regulatory powers to the CFTC over crypto as a way of trying to escape the SEC. But in the process, you may actually be creating a much worse regulator, and you may actually have like a brand new set of issues of regulation by enforcement. So I'm very, very worried about that. And very few people will listen to me about it, and the few others who agree that it's an issue about it. And the other thing that worries me is like the Avi Eisenberg type of stuff, which I mean, we can all agree he did a bad thing, right, and probably deserves to be punished somehow. But in terms of the nuances of how that case went, the like I said earlier, they really shoehorned a DeFi lending protocol into this very traditional framework of representations and are they true or not, and is there a promise to repay, and that is just not how crypto is meant to work. And if crypto does end up needing to work like that, that means every protocol needs a legal wrapper essentially of rights and obligations rather than just incentives and powers. And that means the government is ultimately, it means the legal system and hence the government is in control of crypto. And again, that's not what we're trying to do here, right? So to me, these are like the biggest risks to everything we're trying to build, and also the most slept on risks.
Right. How is Larry Fink going around the CFTC issue, or do they have the license?
I don't know. Yeah, I don't know what he's thinking. I mean, he's really looking at doing tokenized securities and stuff anyway, so presumably it would be under the SEC domain regardless. But I think there's something to think about there because people have just gotten very used to demonizing the SEC, and I get it, and not wanting tokens to be covered by the securities laws. But the thing is, securities laws actually do allow for peer-to-peer transactions. Like it actually is theoretically legal to do peer-to-peer securities transactions, and actually is not theoretically legal to do peer-to-peer derivatives, commodities derivatives transactions. So people really need to think about this stuff. In my opinion, no one should be supporting any of the current crypto bills, even though Coinbase says they're good or whatever. Think about the long game, and don't support something that is going to be bad for DeFi. Wait for something really good. Yeah.
It's crazy because like all of these things can be built from anywhere in the world by people working remotely, and still
Yep.
organizations like SEC and CFTC and whatever else like wield so much power because they can just crush these companies that are based in the US.
Yes, and they have treaties with every other regulator in every other country, right? So yeah, it's just it kind of gives them a lot of power.
Right. Yeah, like, even if you're not based in the US, you could get extradited from a lot of different countries.
That's right. Or I mean, this
Yeah.
is like these things are non-criminal, right? But like violations of securities laws, as long as they're not fraudulent or non-criminal, but you could still, can ruin your entire project. You can lose a lot of money and have years and years of legal battles. So yeah, it sucks.
Yeah. Yeah, I wonder how much innovation was just prevented from stuff like this, or even just like ICOs that then just shifted the investments landscape completely to the VCs and like kind of ruined the whole point of crypto, which is like letting people invest very early on in projects. Yeah,
Exactly.
that's a bit depressing. But let's
Yeah.
let's end on a high note. I don't like ending the
Yeah.
episode on depressing
Yeah, man.
things.
Well, I think on
That's
a
why
high note,
usually.
we have a lot of power. That's the high note, right? Like we can create our own legal structures and we can show to the world that our combinations of tech and and agreements are better than anything that existed before, right? They're more trust minimized, they're more enforceable, they're more efficient, all of those things. We are better than TradFi, right? And once you kind of like build in some of the legal knowledge like we are and add it to the tech, then it's just like so clearly superior than anything that legacy systems have to offer that I think it presents like a really compelling value proposition for the world. And ultimately, that's how you get good regulation and all the other things is just by showing like enormous value, right? And so that is the bright side, and I'm very bullish ultimately. Yeah,
Well said. Yeah, build new systems block by block and show it to the world,
that's
and
right.
eventually they will let us do it or stop
Indeed,
prosecuting
indeed,
people.
indeed.
All right. Any other closing thought?
I think that's it. Check out MetaLeX, and yeah,
Yeah.
always happy to talk to people.
Awesome. Yeah, we'll definitely include. Please send me any important links besides the main the MetaLex links, the Borgs, and the link to your profile. I will include everything in the show notes. So yeah,
Awesome,
thank
amazing.
you very much for coming on. This was fun.
Thank you, man. Great chatting with you. By the way, did you ever end up playing Cyberpunk? I remember we talked about that.
Yeah, I did. I
Cyberpunk
made it through it
2077.
over the during
Nice.
the
They
holidays.
eventually fixed it. It sucked at first, but they eventually fixed it. So yeah, it was
Yeah.
pretty good.